Hey, what's up, everybody? Thanks for watching the Jeremy Dewitte Show right here on YouTube. I've got breaking and exciting news brought to you from the Middle District of Florida, the Federal Courthouse Orlando Division. Now, this is a notice that Jeremy Dewitte is going to have a hearing on January 7th, 2025 for his federal tax fraud cases where he's going to be sentenced. Now, we have a preview of his sentencing memorandum here. Now, this was just posted on the federal docket today. This is a kind of a 2024 closeout and what's going to be happening in Jeremy Dewitte's future. Now, this is very exciting. Breaking news right here on the PoliceTube's Uncle channel. Let's go ahead and read through this. A 32-page sentencing memorandum. It says, Defendant Jeremy Dewitte was indicted in March of 2024 on 2 counts of filing false tax returns in violation of 26 U.S. Code Section 7206 for failing to report most of his revenue he earned from his funeral procession escort business. From 2016 to 2018, he omitted from his tax returns more than $475,000 in gross receipts, causing a tax loss over $100,000. Dewitte pled guilty to both counts in the indictment without a plea agreement. So they're saying that Jeremy Dewitte earned more than $475,000 from his funeral escort business that he didn't report on his income tax returns. That's a lot of money, especially when people thought that he wasn't making any money, basically. It goes on to read, with an extensive criminal history, Dewitte's sentencing guidelines range is 41 to 51 months incarceration. The United States requests this court to impose a 51-month maximum sentence because it is necessary to protect the public from Dewitte's repeated criminal activity and to deter him and others from lying on their tax returns. The United States further urges the court to order Dewitte's sentence to run, get this, to run consecutively to the sentence that the Osceola County Circuit Court recently imposed on him for an unrelated crime. So they're going to have Jeremy Dewitte go to jail, prison for another 51 months after he gets out of state prison next decade. He's already serving, I think, 80-something months in state prison for his crimes in Osceola County, and when he gets out, his federal sentence is going to run consecutive. So he's going to go back in prison for another 51 months for 4 years. Wow. It says, finally, the United States requests the court to order Dewitte to pay $69,461 in restitution as a condition of his supervised release. Dewitte's tax fraud is only the latest in a long series of state and federal crimes that he has committed over the past 25 years. Jeremy Dewitte says he's been running his business clean for 10 years, but the sentencing memorandum says he's committed multiple crimes over the past 25 years. Crimes that reveal his willful and repetitive contempt for the rules of civilized society. It says, like filing false tax returns, most of Dewitte's prior convictions have involved deceiving the public or lying to the government. These include 9 convictions for impersonating a police officer, using a fake name to obtain a driver's license, and using a fake driver's license to obtain a U.S. passport. Dewitte's other convictions include a tax offense and 4 other convictions starting in 2018 and continuing through October of this year for failing to comply with Florida's sex offender registration laws. The court should take his criminal history fully into account when fashioning a sentence. And now it goes on to some facts. It says Jeremy Dewitte was indicted on March 27th of 2024 for 2 counts of filing false tax returns in violation of 26 U.S. Code 7206 for 2017 and 2018. It says on September 25th, 2024, Dewitte appeared before Magistrate Judge Kidd, Embry J. Kidd, and pled guilty to both counts of his indictment without a plea agreement, despite being offered one. On October 15, 2024, the court accepted Dewitte's guilty plea and adjudicated him guilty. The facts underlying Dewitte's tax crimes are straightforward. He lied about his business revenue on his 2017 and 2018 federal individual income tax returns, and as the PSR properly counts as relevant conduct, he lied on his 2016 tax return as well. But those aren't the only lies Dewitte has told in this case. He also lied to the IRS agents who were investigating him, he lied to the court, and he lied to his probation officer. A recap of Dewitte's lies follows, starting with the tax returns. So now they're going to craft this narrative of all of Dewitte's lies, some of Dewitte's lies. It says, since at least 2016, Dewitte has been the sole owner of Metro State Special Services, a funeral procession escort business. It says, see pre-sentence investigation report. As the sole owner, Dewitte was required to report Metro State's revenue and expenses on a Schedule C to his tax return. But for 3 consecutive years, 2016 through 2018, Dewitte filed federal income tax returns, Forms 1040, that understated Metro State's gross income. And it says see Table 1 below, which compares Metro State's actual income with what Dewitte reported. And you can see that here. It says in 2016, he reported $11,000 when his actual income was $145,000, more than $10,000 per month. It says in 2017, he reported $19,000 when his actual income was $174,000. And it says in 2018, he reported $17,000 when his actual income was $205,000. So in total for these 3 years, he reported $47,000 on his income tax return when his actual income was $524,000, over $500,000. The sentencing memorandum goes on to read, naturally, Dewitte's lies about Metro State's income resulted in his underreporting his tax liability for 2016 to 2018 by over $100,000. Said another way, through his lies, Dewitte lined his pockets with more than $100,000 that belonged to the United States. Table 2 shows the tax loss. And it shows here $108,000 in tax loss. Then it details Dewitte's lies to the IRS agents. Dewitte also lied to IRS agents when they questioned him about his tax returns. When asked how he calculated and reported Metro State's income on his tax returns, Dewitte told the case agents that he saved copies of the checks that he received from customers and that he reported all of his income. This we now know from the investigation, which matched client payments and bank account deposits alongside Dewitte's guilty plea, was all false. And Dewitte told other lies to IRS agents as well. He lied about his clients. Dewitte told the agents that in 2017, Metro State had only 2 clients. In fact, Metro State had 40 clients that year. He lied about his profits. Dewitte told the agents that in 2017, Metro State incurred a net loss. But Metro State was profitable that year, even allowing for expenses that Dewitte didn't claim. Metro State's 2017 net profit was over $117,000. He lied about his workers. Dewitte told the agents that in 2017, Metro State had only 2 independent contractors. But in fact, Dewitte had over 25 people working for him at Metro State that year. Then it details Dewitte's lies to the court by saying Dewitte also lied to the court about his failure to appear at his rescheduled initial appearance hearing, which had initially been set by a summons. On April 2nd, 2024, the court issued a notice of rescheduling that hearing to 11 a.m. on April 10th. Dewitte failed to appear. He told his attorney that he had car problems, and the attorney relayed that to the court. The court then rescheduled the hearing to the next day, April 11th. Dewitte failed to appear for that as well. Although he told his counsel that he had been arrested that morning, that was false. The court then issued a bench warrant. Based on his objections to the PSR, Dewitte still maintains that he couldn't attend the April 11th hearing because he was under arrest. Those allegations to the court are dubious insofar as records from the Osceola County Sheriff's Office report that Dewitte was not under arrest at that time of the hearing. Rather, he was arrested that evening when he turned himself into the sheriff's office. And you guys that are watching this, we were there. We watched Jeremy Dewitte turn himself in that day. We watched him not show up for these repeated federal court hearings. And we were wondering, why isn't he showing up? Why is he disregarding these summons? And now we know he was just lying about stuff. It goes on to read, the sheriff's office reports are attached as Exhibits 1 and 2 to this memorandum. The call report indicates that Dewitte called that office at 6:08 p.m., more than 9 hours after his scheduled initial appearance. Osceola County Sheriff's Office call detail report. The arrest reports states that Jeremy Dewitte was arrested on April 11th at 7:34 p.m. See Exhibit 2, Osceola County Uniform Charging Affidavit. Thus, the sheriff's arrest records show that Dewitte was not under arrest at that time of his rescheduled initial appearance hearing. Dewitte's lies to the probation officer. In his interview with probation, Dewitte reported that he earned a bachelor's degree from the University of Florida. Unsurprisingly, the University of Florida has no record of his attendance. I love that they brought that out. You know, it's no big deal, but they still detailed it here because we all looked at that on his probation officer's report and we're like, why is he saying he has a bachelor's degree, you know? And so they called him out on that, and they correctly ascertained that Florida University has never heard of Jeremy Dewitte except through the PoliceTube channel. And then it has a table here with guideline calculations, the PSR calculations. Boring. It goes on to read, Dewitte objects to the obstruction of justice enhancement. However, without a doubt, that enhancement applies to these facts, and the court should overrule the objection. Section 3C.11.1 blah, blah, or whatever, of the sentencing guidelines provides, in pertinent part, if the defendant willfully obstructs or impeded or attempts to obstruct or impede the administration of justice with respect to the investigation, prosecution, or sentencing of the instant offense of conviction, and the obstructive conduct related to the defendant's offense of conviction and any relevant conduct, or be a closely related offense, increase the offense level by 2 levels. The application notes to this section explain that a willful failure to appear at a hearing falls within this section. It says, as the PSR recognizes, this enhancement applies to Dewitte because he willfully failed to appear at his arraignment hearing. The rationale behind this enhancement is that defendants like Dewitte who commit crimes and then make unlawful attempts to avoid answering for them are more threatening to society and less deserving of leniency than defendants who don't defy the criminal justice process. And you can see United States versus Dunningen, 507 U.S.C. 8797, 1993, for that precedent. It says numerous courts, including the 11th Circuit, have thus held that the enhancement under this is appropriate when a defendant willfully fails to appear for his arraignment. We all agree with that. The sentencing recommendation here, we're on page 9 of 32. The United States recommends that the court impose a 51-month prison sentence, followed by a 1-year term of supervised release. This sentence is sufficient, but not greater than necessary to comply with the purposes of sentencing. The government further requests that the court condition Dewitte's supervised release on Dewitte's paying restitution to the United States in the amount of $69,461, which is the tax loss pertaining to the counts of conviction. In determining appropriate sentence, United States Code instructs courts to consider, among other things, the following factors. And this is kind of boring here: nature of the offense, the need for the sentence to reflect the seriousness of the offense, the need to afford adequate deterrence, the need to protect the public, the need to avoid unwarranted sentencing disparities. It goes on to read the nature of the offense and defendant's personal history. I guess this is going to back up some of this. The nature of the offense. Dewitte's tax fraud was greed-driven and repeated. His business took in income of more than $500,000 from 2016 to 2018, yet he reported only $47,000 of that income, less than 10% of the actual amount. Dewitte's fraudulent reporting allowed him to line his pockets with more than $100,000 in untaxed cash. There are no mitigating circumstances underlying his conduct or in his background. Dewitte earned a substantial income and nevertheless chose repeatedly and consistently to lie on his tax returns. And then he lied to the IRS special agents when they caught him. In other words, Dewitte has no excuse for his conduct. It was pure greed. Given Dewitte's personal history, it's no surprise that he would cheat on his taxes. His lies to the IRS and this court are in keeping with his repeated criminal conduct. He has no excuse for this either. His background is inviolable in its lack of remarkability. Dewitte described his childhood as great. He reported that there were no instances of domestic abuse, violence, or substance abuse in his household. Indeed, all of his basic needs were provided for. Yet his criminal history is vast and varied, with 16 felony convictions starting in 1998. When he was 18 years old, and continuing through just a few months ago when he was convicted for failing to comply with Florida law governing convicted sex offenders. Moreover, Dewitte is awaiting trials and sentencing on many more felonies. On January 6, 2025, he is scheduled to plead guilty in an insurance fraud felony case in the Ninth Circuit, Orange County. And on January 22nd, he is scheduled to begin trial on 2 more felony sex offender registration cases in the Ninth Judicial Circuit, Osceola County. There are no mitigating circumstances. Indeed, it is quite the opposite. Dewitte's personal history weighs heavily in favor of a guidelines prison sentence. Then they have a section protecting the public. The sentencing guidelines call for longer sentences for defendants with extensive criminal histories, for good reason. Longer sentences protect the public from recidivists. A defendant's record of past criminal conduct is directly relevant to the purposes of sentencing. A defendant with a record of prior criminal behavior is more culpable than a first offender and thus deserving of a greater punishment. To protect the public from further crimes of the particular defendant, the likelihood of recidivism and future criminal behavior must be considered. Repeated criminal behavior is an indicator of a limited likelihood of successful rehabilitation. Chapter 4, introductory comment, it says here, Dewitte's criminal history shows him to be a committed recidivist. He's a serial recidivist. He has 16 felony convictions since 1998, placing him within the highest criminal history category that the United States has. Many of these convictions involve crimes of deceiving the public. 9 convictions for impersonating a law enforcement officer or lying to the government, lying to the state of Florida on a driver's license application, and lying to the United States on a passport application. His lie to this court about failure to appear for his arraignment is consistent with these prior convictions. He is someone who thinks he is above the law and can lie his way around it to suit his interests. That should be highlighted right there because that's pretty good. Jeremy Dewitte is someone who thinks that he is above the law and can lie his way around it to suit his interests. Apart from the 16 prison sentences he has already received, with sentences of 8 days, 1 sentence, 1 year, 4 sentences, 18 months, 6 sentences, and 4 years on 1 sentence, Dewitte has also been jailed on multiple occasions for violating probation or the terms of his supervised release. Dewitte's criminal history score of 29 reveals him as someone for whom prior prison sentences have had no effect on his willingness to commit more crimes. That's interesting, too, because, as we know, a viewer from the Jeremy Dewitte show, PoliceTube, wrote to Jeremy when he was in prison and was talking to him. And Jeremy Dewitte claimed that this is his first time he's ever been in prison. He has never been behind the gate before, he said, which is another lie. He's lied to the community. The only way to stop Dewitte from committing crimes is to incarcerate him. The need to protect the public thus calls for a guideline sentence that fully takes Dewitte's criminal history into account. It says here, tax crimes are serious offenses. You don't mess with the king's money. The United States tax system is based on voluntary compliance, and individual taxpayers are trusted to honestly report their income and assess their taxes and pay over what they owe to the government. Pay over or overpay? Honestly report their income and assess their taxes and pay over what they owe to the government. Yet the system of voluntary compliance is often abused, and federal resources are such that not all tax crimes can be prosecuted. For these reasons, deterrence through sentencing is of paramount importance. honest taxpayers need to know that they are not dupes for following the law, and they need to know that those who cheat will be punished for their crimes. The 11th Circuit Court has repeatedly endorsed this principle, setting aside sentences in which the imprisonment was inadequate to promote deterrence. Defendants in white-collar cases often calculate the financial gain and risk of loss, and white-collar crime therefore can be affected and reduced with serious punishment. It says deterrence is an important factor in white-collar cases where the motivation is greed. American greed. We have set aside sentences of little or no imprisonment because they do not constitute just punishments for the offense. They do not promote the respect for law and will not do much to deter similar criminal activity by others. And indeed, studies have shown that the salient examples of tax enforcement actions against specific taxpayers, especially those that involve criminal sanctions, have significant and positive deterrent effects. It says a sentence lacking a significant prison term would entirely fail to serve the goal of general deterrence. A lenient sentence would encourage tax cheating and send a message that tax fraud will be tolerated and that those who engage in it will not be held accountable. Such a sentence would provide a would-be tax cheat every incentive to perpetuate a tax fraud scheme where the reward is high and the chance of being caught and prosecuted is low. The United States respectfully submits that this is not the message that this court should send to the public through its sentence of Dewitte. The need for general deterrence, as called for in 18 U.S.C., demands more. It goes on to read sentencing disparities. We're on page 15 of 32. As the Supreme Court has observed, one of the chief aims of the sentencing guidelines, even in their advisory role, is to promote uniformity and avoid unwarranted disparities in sentencing. Here, a guideline sentence will promote these goals. According to the most recently published data from the United States Sentencing Commission, 63% of the individuals sentenced for tax fraud in fiscal year 2023 received a prison sentence. And unlike Dewitte, more than 86% of those defendants had little or no criminal history. The median tax loss was approximately $360,000, and the average person sentenced was 16 months. While guideline sentence for Dewitte would exceed the average prison sentence for tax fraud cases, this is largely due to his criminal history. The average tax cheat does not have a prolific criminal history. In contrast, Dewitte is a serial criminal. Because of his criminal record, the guideline calculation appropriately categorizes him in Category 6. Accordingly, his sentence calculation is longer. Had Dewitte been in Category 1, like most tax fraud offenders, and were he not to receive an obstruction of justice enhancement, his offense level would be 13, and the guideline sentence would obviously be less. The guidelines calculation appropriately considers Dewitte's fulsome criminal history, and the sentencing guideline range reflects the sentence appropriate for a serial criminal with dozens of prior sentencing events. Thus, there is no disparity between Dewitte's guideline sentence and the national average of tax offenders at the highest criminal history category of 6. His guideline sentence is the product of his serial criminal conduct. It says Dewitte's sentence should run consecutive to the sentence recently imposed by Osceola County. It says on November 1st, 2024, Dewitte was sentenced by the Osceola County, Florida Circuit Court to 83 months in prison for failing to comply with Florida's sex offender registration law. The court should order that its sentence for Dewitte tax fraud case shall run consecutive to the Osceola County sentence. As the 11th Circuit has recognized, the federal courts are authorized to impose a federal sentence that is consecutive to a state sentence. Because Dewitte's tax fraud and sex offender failure to register convictions are wholly unrelated, the guidelines permit the court to impose a sentence that is consecutive, concurrent, or partially concurrent. To achieve a reasonable punishment for the instant offense, it says the result would be otherwise if Dewitte's state court sentence were for an offense that was related conduct to the instant offense. It says the advisory notes to this instruct the court to consider the following factors in a case where a defendant is already serving a sentence in an unrelated crime. There's a bunch of stuff there. You can read that if you want. It says here, the above factors warrant a sentence that will run consecutively to the Osceola County sentence. As set out above, the factors counsel strongly in favor of a substantial prison sentence, and while Florida does not allow parole for people convicted after 1983, inmates can obtain early release after serving at least 85% of their sentence. At most, Dewitte is 2 months into his 83-month Osceola County sentence, but his past experience with prison sentences has shown that those sentences do not deter him from committing future crimes. That fact counsels in favor of a consecutive sentence here. The surest way and only way to deter Dewitte from committing more crimes and to protect the public from him is to incarcerate him. We need to quote that as well. The surest and only way to deter Dewitte from committing more crimes and to protect the public from him is to incarcerate him. Wow. It goes on to read, the 11th Circuit has repeatedly recognized that the sentencing guidelines reflect a preference for consecutive sentences when imprisonment terms are imposed at different times. And it has repeatedly affirmed district courts that are ordered consecutive sentences when the federal offense was unrelated, pending, or anticipated state court sentences. And it has some precedent here. Were the court to order that Dewitte's tax fraud sentence run concurrently with Osceola County's sentence, the result would be the same as if the court were to impose no prison sentence at all. Not only would that send the wrong message to Dewitte and the Jeremy Dewitte community, it would also waste the substantial resources that the United States has expended in investigating and prosecuting Dewitte for his tax fraud. The message a concurrent sentence would send to the public is that tax crimes are not serious and that courts are reluctant to impose those to imprison those convicted of those crimes. But the right message that needs to be sent by this court is that if you cheat on your taxes, you will face prison time. Then it says the court has authority to condition Dewitte's supervised release on his paying restitution. You guys can read through that if you want. A little boring. Basically says the United States is the victim, and its loss for the 2 counts of conviction is $69,000. Justice mandates restitution, and the court should therefore exercise its power to condition Dewitte's supervised release on his paying restitution to the United States. All this effort they put in this, and they can't even spell United States properly on a sentencing memorandum. Conclusion. They probably could have paid for extra spell checkers, by the way, if they had that $100,000 in tax money from Dewitte. It says Dewitte's tax fraud cannot be reduced to an oversight, a mistake that spiraled out of control, or a single instance of lying. Jeremy Dewitte lied on 3 consecutive tax returns and lied some more when the IRS caught him. He then lied to this court about his failure to appear at the initial appearance hearing, attempting to delay his reckoning, and he lied again to his probation officer. This court should protect the public and deter Dewitte and others by imposing a serious prison sentence here. The United States respectfully requests, therefore, that the court impose a guideline sentence and sentence Dewitte to prison for 51 months, the maximum, followed by a 1-year period of supervised release, with such release conditioned on Dewitte paying restitution to the United States. And then it's submitted by Roger Handberg, the United States attorney handling this case, and to Curtis Wilder, the trial attorney. And Let's see what else we have here. A certificate of service. Here's the Exhibit 1, the call detail report that they were talking about when Dewitte was turned himself in. And there were some other exhibits there, but I don't want to show them here because it might have contained some private information, so I don't want to get this video flagged by YouTube. Has some proposed language for a sentencing order, kind of boring stuff, but that's it. For 2025 and therefore forward, Jeremy Dewitte is going to be in prison for a long time. This is about 13 years total from his state cases to his federal case, plus he still has more trials and guilty pleas coming down the pipeline early January. Jeremy Dewitte will be sentenced in his federal tax fraud case on Monday, January 7th, 2025. You can stay tuned right here to the Jeremy Dewitte Show on YouTube, brought to you by PoliceTube's uncle. PoliceTube's far removed uncle, by the way. It's all going to be revealed and detailed for us here. I appreciate you guys watching. This is unbelievable. Jeremy Dewitte spending the rest of the decade in state prison, and then once he gets out, he'll be spending the next 4 years or more in federal prison for tax fraud. Wow. Whoever thought they'd see this coming? My first Jeremy Dewitte video was here on PoliceTube on YouTube, April of 2021. Jeremy Dewitte was already arrested, and that was right after the pepperball incident on the freeway with Vidler. And we've seen so much happen. Then back then, people didn't even know that Jeremy Dewitte was in a RICO investigation that was being shut down by the Orange County Sheriff's Office as part of a corrupt scheme to protect Jeremy and his business partner, which was also a friend of the Orange County Sheriff, John Mina. They were working in conjunction to try to cover up some of Jeremy Dewitte's activities. That way, they didn't, it didn't come to light that Jeremy Dewitte was working with prominent people of the community that were trying to protect him and make money off of these schemes. And when people at the Orange County Sheriff's Office saw that there was corruption happening, they blew the whistle, like Ramsey and Vidler, and they were threatened with being fired. And they said that they're going to become whistleblowers, and they did become whistleblowers, and they got fired and punished by the Orange County Sheriff's Department. And one thing that we want to remember about all of this, not just that Dewitte was on a 25-year spree of committing crimes, but that he lied in a police complaint to the Orange County Sheriff's Office that got decorated sheriff's deputies, sergeants, and corporals punished and fired from their job. And Sergeant Keith Vidler is still fighting Orange County Sheriff's Office Sheriff John Mina in court in Orange County, Florida, trying to get restitution for him losing his job simply for arresting Jeremy Dewitte and recognizing his crimes. And John Mina told him, stop investigating Dewitte, leave Dewitte alone. And John Mina ordered that Jeremy Dewitte be given his gun back and be released, and there an apology be issued. And he did that because he was trying to cover up the crimes of Jeremy Dewitte and his business partner, which were friends with John Mina, the sheriff, the corrupt sheriff of Orange County, who's still sitting in his sheriff's office, covering up other crimes, by the way. You've all seen the videos where the police officers under his direction beat up that one suspect and knocked the guy's eyeball out. And then they brought him in for questioning without getting him any medical support and left him there in an interrogation room. And John Mina himself walked in, saw the guy sitting there bleeding with his eye basically popped out of his head. And John Mina laughed and walked away. Now, of course, nobody likes that criminal because, he killed a police officer. But John Mina said that Vidler violated Jeremy Dewitte's rights, so he needed to be fired. But John Mina never fired anybody else for popping a suspect's eyeball out and leaving him in an interrogation room. John Mina laughed about it. It's because he's doing what serves him best, trying to cover up crimes in his department under his watch. So this may be about Jeremy Dewitte, but it's also about political corruption in Central Florida by politicians. Thanks for watching the Jeremy Dewitte Show exclusively on YouTube. I appreciate you guys. This brings to a conclusion the year 2024. Today's today's December 31st, 2024. Happy New Year. Happy rest of your decade to everyone other than Jeremy Dewitte. Thanks a lot, everybody. Have yourself a great day.